In this intense moment in a confirmation hearing, a back and forth that looks simple on the surface, yes or no questions, but actually exposes three big things we should all care about: how advisors to President Trump interpret the law, the role of the Office of Legal Counsel, and what it means for the rule of law when officials give evasive answers.
So let me start with you, Mr. Edlow. Yes or no? Would you ever advise the administration that it could ignore or disregard an applicable district court order because you believe the Supreme Court will ultimately overturn it?
Senator, as I said before,
yes, just a yes or no
I don't
question.
believe I'll ever be in that position.
But you may not. But just like you answered Senator Kennedy, I want to make sure that you were not misleading anyone. So let me ask the question again. Would you ever advise the administration that it could disregard an applicable district court opinion or order because you believe the Supreme Court will ultimately overturn it? Yes or no?
I don't want to speculate, but I can't see a situation where I would advise to not follow a court order.
So your answer is no, you would never advise them to disregard a district court order, even if you thought the Supreme Court
Again,
would
I don't want to
overturn
speak. I don't want to speak.
I just want you to be precise and answer yes or no.
I can't see a time where I would do that. No.
Okay. Mr. Geiser, yes or no?
Thank you very much, Senator Schiff. I would advise clients to follow court orders.
Even if you believe the Supreme Court would ultimately overturn the district court?
Well, Senator, as far as
yes or no?
the answer is the same. The president has said he will follow court orders.
The same answer, yes or no?
Senator, the president has said he will follow.
You were able to answer Senator Kennedy, but I want to make sure that you were not misleading Senator Kennedy. Yes or no, would you ever advise the administration it could ignore a district court order because you believed the Supreme Court would ultimately rule otherwise? Yes or no, would you ever advise them that?
Senator, applicable court orders should be followed.
That's not my question. Yes or no?
Senator, you asked me.
Yes or no, Mr. Geiser? It's a simple question.
Senator?
Mr. Geiser, you were able to answer Senator Kennedy. Are you raising a doubt now about your answers to Senator Kennedy because you can't answer this question?
Senator, I would advise clients to follow applicable court orders.
Is that a yes or no?
I would advise clients to follow applicable.
Is that a yes or no? Let me repeat the question so there's no ambiguity about it. Would you ever advise the administration, you're going to be, if you're confirmed heading the Office of Legal Counsel that helps determine whether actions are lawless or lawful, would you ever advise the administration that it could ignore an applicable district court opinion or order because you believed the Supreme Court would ultimately overturn the order? Yes or no?
Senator, if I'm confirmed to lead the Office of Legal Counsel,
all right.
I would.
You're not answering the question. So I guess the answer is to Senator Kennedy, you just might advise the administration to ignore a district court order. How about you, counsel?
Thank you, Senator Schiff. In my role as director, I am not
asking yes or no.
Well, thank you. I wish to clarify, I'm not, if confirmed, a director. I'm not acting in a legal capacity at all. I'm part of the executive agency branch, and therefore would not be advising clients on any aspects of that.
Well, would it be appropriate, in your view, for anyone else among legal counsel to do so?
In general, court orders should be followed and respected. There are situations which I recall back from law school.
I guess you're not able to answer the question either. Counsel, how about you?
Senator Schiff, thank you. I mean, I agree. I don't believe it's appropriate to address this hypothetical. At the Department of Justice,
so you want to revise your answer to Senator Kennedy then? That is, there may be circumstances where you advise the administration to disregard a district court of opinion because you believe the Supreme Court might rule otherwise. Is that your opinion?
As a lawyer, the answer is it depends.
Okay, thank you. Then we'll make sure Senator Kennedy is aware that you just might, it depends, advise the administration to ignore court orders.
Senator,
let me ask another question. Mr. Geiser, would you agree that it would be unlawful for the president to accept a gift from a foreign state without the consent of Congress? Would you agree that's unlawful?
Well, thank you for that question, Senator.
Yes or no?
Whether something is lawful or not, I would always want to look.
I'm just asking you a simple question. Is it unlawful for the president to accept a gift from a foreign state without the consent of Congress? Very simple question.
Senator, as a lawyer, I would always give my...
I'm not asking you for a preamble, just yes or no.
Well, Senator Schiff, it depends on the facts.
Well, Mr. Geiser, where is the depends on the facts of Article 1, Section 9, Clause 8, which says, no person holding any office shall, without consent of Congress, accept any present from any foreign state? That's the Constitution. It doesn't say, well, it depends, or it might, or maybe. It says, no person shall do so. Do you find that ambiguous?
Senator,
I thought you were supposed to be the strict constructionists. This is what the Constitution says. Is there an exception for $400 million planes from Gulf emirs?
First, why the yes or no line of questioning matters. Senators repeatedly pressed the nominee and the counsel with a foundation-level question. Would you ever advise the administration to ignore a district court order because you thought the Supreme Court would eventually overturn it? That's not academic hair-splitting. District courts issue binding orders. If the executive branch treats those as optional based on what someone predicts the Supreme Court might do, you replace predictable, enforceable law with a game of political or legal roulette. The Office of Legal Counsel, OLC, exists precisely to provide principled legal advice that constrains executive action, to translate the law into what the administration can or cannot do, not what it might wish the law to be later. Second, read the answers carefully, not just the tone. In the excerpt, nominees gave answers that ranged from "I can't see a time I would do that" to "It depends on the facts." Those may feel like denials, but the important detail is the qualification. "I can't see a time" is not the same as "I would never." "Depends on the facts" is a legitimate observation in many legal contexts. Facts matter. But when the question is whether a lawyer would advise ignoring an enforceable court order, an answer that leaves room for exception is consequential. It suggests the possibility that the advice could be, go ahead, ignore that order under some circumstance. That's a material risk when we're talking about the executive branch and the OLC's authority. Third, the constitutional anchor. Senator Schiff points to Article 1, Section 9, Clause 8, the Emoluments Clause, to highlight a different but related problem, constitutional text that appears straightforward being reduced to "it depends." The clause forbids office holders from accepting gifts from foreign states without Congress's consent. It's framed as categorical. The question is whether a lawyer tasked with advising the White House would treat that as categorical, or allowing factual carve-outs that effectively swallow the rule. When constitutional language is treated as vague in a way that benefits political actors, you move from rule-based governments toward discretionary politics. Why this matters in day-to-day terms. If the executive is told it may ignore district court injunctions because someone predicts a higher court will overrule them, ordinary people and institutions lose predictability. A business, a public health official, or a private citizen who obtains a court order to halt unfair practices or to protect rights needs to know that order will be obeyed while the appellate process runs. If court orders are optional, the consequences are practical and immediate. Rights delayed are rights diminished. Enforcement becomes inconsistent, and the balance between branches shift. A few practical things viewers should understand about the OLC and confirmation hearings. The OLC's written opinions often become the legal posture of the entire executive branch. An OLC memo can authorize or forbid conduct and is treated as the administration's legal rationale. That's why the Senate's questions aren't abstract. They determine whether future decisions will rest on sturdy legal reasoning or on shifting interpretations that bend under political pressure. "Depends on the facts" is often true in law, but when the question is whether to follow a binding court order, that phrase should come with a clear explanation. What facts could justify noncompliance? What procedures would the OLC require before recommending noncompliance? And how would constitutional duties be weighed? Vague answers deny the public the ability to evaluate the nominee's likely approach. Nominees' posture toward adherence to court orders is a good proxy for how they view separation of powers and legal constraint more broadly. Senators have a legitimate role in probing whether the nominee will uphold institutional guardrails. How to read this exchange without spinning into partisanship? Focus on the institutional stakes. The substantive worry here isn't which party benefits today, it's whether the rule of law will be treated as an anchor or as a tool. That is a concern for anyone who expects government to play by rules rather than preferences. Concrete takeaways you can use immediately. If you want to evaluate a nominee, look beyond single-sentence answers. Press transcripts and full hearing videos reveal qualifiers and evasions that headlines smooth over. Read the exchanges and note where nominees add "it depends" without explaining the boundaries.